Central Arbitration Committee and another.
Lord Hendy.
My Lords, I appear for the Union in this case, leading my learned friends Catherine Newton and Madeline Stanley. My learned friends Christopher Jeans leads Mr. Tom Cross and Raphael Hogarth for the second respondent, Deliveroo. My learned friends Mr. Daniel Stillitz leads Mr. Stephen Cosmin, the intervener, the Secretary of State for Business and Trade. Lords, the first respondent, the Central Arbitration Committee, which I'll refer to as the CAC, in accordance with its usual practice, which it followed in the courts below, does not appear. Lords, I understand it's not inappropriate for me to say that all counsel and solicitors for the Union are acting pro bono in this case. Lords, I understand there's been some difficulty with the electronic bundles, a difficulty which I shared myself, namely that I could get the documents up, but I couldn't underline anything.
Exactly.
I understand that a hard copy bundle is coming at lunchtime. I don't know whether one of your lordships needs it, but
right.
It's
I mean, the problem which was identified yesterday is the difficulty of highlighting it.
Yes,
it can be done eventually, but there has about a 30-second gap, which
so
is going
long.
to totally disrupt the hearing if we were to try and do
My
that.
Lords, your lordship's got more patience than I gave up, and I've resorted to the old-fashioned method, which is why you see this large box in front of me.
Right.
Forgive me.
We don't have hard copies at the moment, but we hope that might be put right later.
I'm obliged, Lord. Lords, subject to your lordship's convenience, I was proposing to address the court under some 14 headings. All but the last two are devoted to our first ground of appeal, namely that the Court of Appeal erred in holding that Article 11.1 was not engaged. And Lords, for your lordship's convenience, those headings are: number 1, the issue; number 2, the CAC decision; number 3, Article 11; number 4, collective bargaining; number 5, Schedule A1; number 6, workers; number 7, Section 296 and the substitution clause; number 8, the European Court of Human Rights authorities; number 9, the basis of the entitlement to the right to bargain collectively under Article 11; number 10, a purposive construction of Article 11 entitlement; number 11, the interaction between Article 11 and Schedule 1; number 12, EU law; and then finally 13, Article 11.2, and 14, reading down Section 296. Lords, I begin then with a short statement of what we are perceived to be the issue in the appeal before your lordships. Deliveroo engages cycle riders to deliver cooked food from restaurants to customers. The simple issue before the court is whether, in the light of Article 11, a right of substitution, which the riders never asked for, which was imposed on them by Deliveroo, and which few, if that, have ever used, debars their union from admission to the statutory recognition procedure to enable it to attempt to negotiate with Deliveroo pay, hours and holidays on their behalf. Lords, I begin then with the CAC decision. Your lordships have that in the bundle of key documents, for those who are manual, tab 9, page 169. Lords, I know your lordships will all have read this, but I hope that it would be helpful if I just draw attention to some passages within it which we think are of particular significance. Lords, I begin at page 171 in the CAC's...
I'm sorry, we're having serious pagination.
I'm so sorry, my lord.
Pagination issues with the electronic bundle.
I think we're all using the... Yeah, but
Yeah,
I think we're all using the main bundle.
We're all using the main bundle.
Oh, I see. Not the key.
Well, I'm not. I'm using the key documents bundle.
So be it, my lord. I'll just give your lordships in a moment. Miss Newton will give me the...
258 in the main bundle.
Yes, 258. I'm very grateful. So, For convenience, then, I shall refer simply to the paragraph numbers, if I may. And I was going to begin with paragraph 7.
Just to be clear about this, some of us are working off the key documents bundle.
Right.
Others are not.
I shall endeavour to give both references where I can, my Lord. So, paragraph 7, at any rate, in whichever bundle is most convenient, and I was going to pick it up in the page which continues a paragraph 7, which begins at the top, your favourite restaurants. And I draw attention to the third line down with a sentence that reads, all drivers in London were assigned to a specific zone. Drivers' work revolved around this zone assignment. Lords, I don't read the next sentence because there was controversy about the extent to which drivers worked in or out of the area of the zone. But I continue the next sentence. Drivers were only sent to collect food from restaurants within the allocated zone, and rarely would they deliver food outside the zone, such as when a customer was based just outside the zone. Different zones had different pay structures. For example, in Camden, drivers were paid a piece rate of £3.75 per delivery. However, in Battersea, most drivers were paid a combination piece rate, hourly rate, of £7 an hour plus £1 per delivery. Per delivery. Deliveroo managed each zone separately with managers assigned to specific zones. Lords, I turn from that to paragraph 13 on the next page. Deliveroo's comments on those can be picked up in the last 4 lines of the paragraph. Deliveroo added that the concept of a zone, such as CKT, Camden, Kentish Town, was somewhat vague and nebulous. 216 riders were registered in KCT, but being registered to work in a particular area didn't tie suppliers, that's riders, to work in that area. And then they gave an example of the number of people who had performed in that area. Lord, I was going to turn from that some pages on to paragraph 34, which in the key bundle is at 178, which is headed The Facts. And in the electronic bundle, that is page
267.
267, I'm obliged. So, Lords, I don't read all these facts out, knowing your Lordships have looked at them, but I pick up the last sentence of paragraph 35. We, that's the CAC, shall refer to them as riders. They're accurately described as the face of Deliveroo, as they will usually be the only human interaction the customers have with Deliveroo. Then in paragraph 37, second sentence, these were riders who were referred to by Deliveroo as having an ops code of CKT, which stands for Camden, Kentish Town, referred to a food delivery zone with those initials. And 38, Deliveroo registered all riders, including fee per delivery riders, FPD, with an ops code such as KCT, and then it refers to the dispute as to the extent that dominated the areas in which the riders worked. Over the page under recruitment, pick up the second part of the first sentence. There's a considerable emphasis on the sense of community and team spirit shared by the riders. And in 40, Deliveroo emphasises the personal nature of the service provided to its customers, advertising, we have a fantastic team of drivers who take pride in getting your food to you as quickly as really possible. And then how they describe them. In 41, in recruitment literature, Deliveroo emphasises the importance of its riders to the company and seeks to engender a sense of belonging to the Roo community. And in 42, they describe the riders as the very lifeblood of our company. Without them, Deliveroo wouldn't exist, a fact at the very heart of how we operate as a business. And then in 43, they describe what's referred to as the onboarding process, as your Lordships see, an online application form followed by a telephone interview, the purpose of which is a sift the CAC found. And over the page at 44, that's followed by a trial session during which the riders and their bicycle are assessed by Deliveroo trainers. At 46, the next phase of the process involves attending at Deliveroo premises to complete an online training course. It involves watching a number of detailed videos containing instructions on how to carry out the role. These videos have learning points at the end and online multiple choice tests which riders must take and score 100%. There's no limit to the number of times they can retake that, to demonstrate the rider's understanding of the topics covered. In 47, there's considerable emphasis on the need to present well as the face of Deliveroo, as a customer service with a frontline role, as well as detailing advice on such matters as how to wash your hands and other aspects of food hygiene and health and safety, stressing the important responsibility of food handling for customers when working for Deliveroo. 48, criminal record bureau checks are undertaken and paid for by Deliveroo before any rider is accepted. Lords, in 50, it says that Deliveroo has taken on very few new riders in CKT in order to avoid an oversupply of riders as a way of regulating the market to ensure there's sufficient work available for its riders. In 51, your Lordships will see...
Is there any indication of what is regarded as sufficient work?
No, my Lord, there's no, my Lady, there's no indication either in the facts found, and I don't recall in the evidence either. So whatever Deliveroo thought was the right amount of work for the right amount of riders didn't emerge. Lords, in paragraph 51, in the middle of the paragraph, the Lordships will observe that new contracts were introduced just before the first hearing, the new contract. The parties agreed at the last sentence that the panel should consider the question of worker status by reference to the new contract and not the earlier contract. In 52, the terms of both the earlier and new contracts, and indeed all the contracts with riders that have been issued at any time by Deliveroo, are set by Deliveroo, and there's no scope for individual negotiation. Riders are required to sign the contract if they wish to become a Deliveroo rider. In 54, the new contracts were delivered with a covering letter which specifically drew attention to the substitution clause, and that's set out in the sentences that follow. Lords, I was then going to take you to paragraph 57, and the reason is because I'm going to show your Lordships the actual new contract in due course, so it doesn't help to look at it here. But I pick up in paragraph 57 on the opposite page, fee per delivery riders are paid on a, fee per delivery basis. The payment is for each completed delivery, defined as the collection of order items from a partner and delivery to a customer. Deliveroo prepares a draft invoice on a fortnightly basis, and it's understood that that is the fortnightly is the interval of payment of the remuneration. Lords, in 58, the decision reiterates that the rider provides various warranties as strict conditions of the new contract, such as right to residency and so on, which we'll come to when we look at the contract. Lords, I go over the page and won't read more of the contract there, but I I pick up at paragraph 60 that the rider may terminate the new contract at any time for any reason on giving Deliveroo immediate notice in writing. And Deliveroo is required to give the rider 1 week's written notice of termination for any reason and with immediate effect in the event of any serious or material breach of any obligation owed by you, including for the avoidance of doubt, where such breach is the responsibility of any substitute engaged by you. 61, fairly standard clauses concerning confidentiality and data protection, including you and any substitute will maintain password protection on the smartphone that you use in the provision of the services and keep your app login details and password confidential at all times. Lords, I go to paragraph 64. Deliveroo does not provide a pension or other benefits such as life assurance or permanent health insurance. Previous restrictions on wearing competitor clothing and an obligation to wear at least one piece of Deliveroo branded equipment have been removed from the new contract. Over the page at 65, after the new contract was sent on the 11th of May, the next day on the 12th of May, there was a communication which addressed the issue of swapping orders, and that ends in the last couple of sentences. So if you ask someone else to complete a delivery assignment to your phone, it's important that they have your phone with them while completing that delivery. This will ensure that the customer always receives accurate GPS data to track where their order is. In 66, the Deliveroo app, which each rider obtained, is dealt with in the second half of the paragraph. It can be downloaded to any number of devices, but used by only one at any one time. It's not possible to sign in simultaneously on multiple devices. The app is the sole means by which riders are made aware of deliveries available for collection from partners for delivery to customers. And then in 67, third line down, they operate exclusively on a free login basis, meaning they, the riders, can log in and log out of the app whenever they chose during opening hours, which is those hours being when restaurants are open and customers are making orders. A rider couldn't, for example, log in at 3 a.m. in an area where all restaurants were closed, and subject to the requirement that they perform at least once every 3 months. And then in 68, in the third line, reiteration of the £3.75 per delivery in that zone. However, the fee offered to riders for each delivery varies to some degree depending on demand. Surge pricing, higher fees may be offered when demand is particularly high and there's a need to incentivise riders to go out on the road. And your Lordship see in paragraph 69 in the last couple of lines that riders can swipe right on their screen to make themselves available if the zone they're in is open at that time, and in 70 they can swipe left to make themselves unavailable at any time unless they've already accepted an order which has not yet been delivered, and they can click on my last order and no more deliveries will be offered to them. Lords, in 71, the mechanics are set out. The only point I pick up is the sentence beginning in the fourth line. If the rider rejects or doesn't accept the job by ignoring the request within 3 minutes, the job is offered to another rider. And in 72, I pick up the last sentence that the riders will only be considered available to accept another order after they've confirmed delivery of the previous order. And 73 mentions stacked orders where a rider is asked to take 2 orders from the same restaurant to different locations, but says that is only occasional. I go down to paragraph 76. There's no policing by Deliveroo of a rider's use of a substitute. Should she choose to use one, Deliveroo simply relies on the contractual terms of the rider. In practice, substitution is rare, as there's no need for a rider to engage a substitute. Lord, that is an important consideration we submit. And in 77, the last sentence on the page, fee per delivery riders are vulnerable to having their contracts terminated on 1 week's notice if their or their substitutes' delivery times over a sustained period are deemed too slow. And in 78, another important sentence, a few, if that, riders use substitutes. And then there was a survey, which Lordships don't need, and I pick it up in the middle of the paragraph, some 6 lines down. All that is required is for either the substitute to download the app onto her or his own phone, or the rider lend their device to the substitute. Either way, the substitute would need to be privy to the rider's Deliveroo password, and the CAC says the confidentiality clause permits that. In 79, another important sentence, most riders do not use a substitute. If they don't want to do Deliveroo deliveries, they don't log onto the app. And in the next sentence, we've set out above the provisions in the new contract that make the rider entirely responsible for the substitute, including insuring them, and the rider has to trust the substitute with her or his delivery passwords. And then this important sentence, the vast majority of riders see no point in engaging a substitute. However, in 80, a few riders do, however, and one rider gave evidence of taking 15 or 20% of the fee from a substitute engaged by him. And in 81, another single example of a rider accepting a delivery and then changing his mind and substituting the job after acceptance. And of that it said, it will be very rare indeed that this will happen in practice. What would be the point? Lords, in paragraph 82, if a rider's unable or doesn't want to complete a job after accepting it, and doesn't want or is not able to pass it on to a substitute, they have to telephone rider support, who will arrange for another rider to take over the job. 83 notes that some riders are also signed up to other food delivery organisations such as Uber Eats, and Deliveroo doesn't object to that. The union doesn't believe Deliveroo that it's a vast majority, but they do accept that a goodly proportion may sign up to other organisations. So consequently, 84, some riders can and do have several apps open at once, including the Deliveroo app. Lords, I take your lordships to paragraph 86 next, and the second sentence, which reads the contractual...
Read the rest of that sentence, please.
Yes.
That first sentence.
Learned friend asked me to read the rest of the first sentence of 84. Some riders can and do have several apps open at once, including the Deliveroo app, and take jobs as and when they're offered from whichever company offers first at the moment they're available. It makes sense since it maximises the chance of work. Lords, in paragraph 86, the panel consider the position as at May 2017 under the new contract and the position in practice. Contractual terms under the earlier contract and in practice were markedly different and involved much more control and direction by Deliveroo. 6 strict uniform requirements, a different attitude to substitutes, and in other significant respects. Of course, the CAC then deals with the parties' submissions, and if your lordships will be good enough to turn over a couple of pages to get to page 98, paragraph 98, under the CAC's discussion and conclusions. In paragraph 98, they say, an issue that puzzled the panel considerably was this. Deliveroo stressed the total flexibility of its riders' ability to log in to the app as and when they wished, and ability to pass on offers of delivery even when logged on, and even to abandon the delivery midway by just ringing service delivery support desk. In such circumstances, why would the question of substitution ever arise? Why would a rider bother to engage a substitute? And why would Deliveroo spend so much time, money and energy selecting and training riders when the riders could then subcontract the right to use the app willy-nilly? We termed it the substitution conundrum in our deliberations. What would be the point of using a substitute if you were a rider, and why would you let a rider do it if you were Deliveroo? And my submissions about that, there was that it was unreal, and then in 99 Mr. Jean's response, which the CAC described as bland. It was that if Deliveroo was willing to invest in training for its riders, knowing that they could subcontract whenever they wanted, then that was up to them. If they're willing to risk their riders subcontracting to unsuitable types who hadn't washed their hands in accordance with a training video, resulting in the customers being unhappy with a person on the doorstep, that was their choice. The panel's role is not to judge the good sense or otherwise of the business model. Even if they did it in order to defeat this claim and in order to prevent the riders being classified as workers, then that too was permissible. All that mattered was the terms of the agreement analysed in the holistic and realistic way set out in AutoCleanse. Mr. Jeans, of course, made no concession that either proposition was accurate. Deliveroo's purpose in deciding the terms of the agreement, there was no question that the riders had any direct say in the matter, was immaterial. All that matters was what the terms actually were. And then the conclusion which defeated us, Lords, is at paragraph 100. The central and insuperable difficulty for the union is that we find that the substitution right to be genuine in the sense that Deliveroo have decided in the new contract that riders have a right to substitute themselves both before and after they've accepted a particular job. And we also have heard evidence, which we accepted, of it being operated in practice. So, my Lords, that's the reason why the application failed under UK law. And in paragraph 101, the sequela of that is that in the light of our central finding on substitution, it cannot be said that the riders undertake to do personally any work or services for another party. It's fatal to the union's claim. In paragraph 102, this appears, some riders do few and intermittent jobs for Deliveroo, but many riders do as much work as possible insofar as they can, given other commitments, and place themselves as close to as possible to restaurants so they'll be offered work by the Deliveroo algorithm. They rely on it as their main source of income. But that's not the applicable test under section 296, which I shall come to in due course. The next sentence leave out the delivery has to be undertaken by a person, however, it doesn't have to be the rider. Riders are free to substitute at will, also appreciate high level of trust required in the substitute by the rider, both because the substitute has either the rider's phone or Deliveroo passwords to download the rider's app onto his or her phone, and because of the contractual commitments borne by the rider on behalf of her substitute, particularly in light of Deliveroo's right to end the contract for any reason on a week's notice, which limits the attractiveness of subcontracting, coupled with a lack of incentive for doing so. But that doesn't make the substitution provisions a sham. In paragraph 103, just one sentence, the last one beginning on that page, panel was concerned about public safety and food hygiene and the way the new agreement seeks to place all risk and responsibility on the shoulders of the riders. And then at paragraph 104, Hendy made a secondary submission pursuant to Article 11 of the Convention and the Human Rights Act. However, on the specific facts of this case and the unfettered genuine right of substitution that operates both in the written contract and in practice, the argument doesn't succeed. In a less clear-cut case, the position might have been different. And of course, that's the issue which brings us in front of your lordships today. I should say, just in passing, that submissions about Article 11 were made, in fact, in opening the case, in a second opening skeleton which we submitted, and also in closing. But I accept, as Mr. Jeans will no doubt stress, that it was a secondary submission because we thought we were strong on the UK law. Lords, from that I go to what is page 204 in the key bundle at paragraph 131, and it is and page 293 of the electronic bundle. So paragraph 131. Here the CAC is dealing with the consequential matters which were before them. We didn't get over the first hurdle, so that these consequential matters were no longer material. But I just draw attention to what they found. I can pick it up in paragraph 131. The unions has been able to demonstrate considerable and consistent levels of support over the unfortunately long period of this case, notwithstanding Deliveroo's opposition to the union's claim, and notwithstanding the difficulties of organising and contacting other riders and the individual nature of the work. Being a one-person cycle delivery rider is by definition a solitary activity. I'll leave the next sentence, and then from all the information before us, if the riders had been workers within the meaning of section 296, we would have found that a majority of the riders in the proposed bargaining unit would support the union's bid for collective bargaining on pay hours and holidays. From the industrial relations expertise of the panel for which we were appointed to the CAC, we infer that the support and membership levels demonstrate an appetite and interest in collective bargaining beyond those who have made themselves visible. And finally, my lords, I turn to paragraph 133 opposite. In considering all the evidence and circumstances of this case, we conclude that the declared support of recognition and sustained significant membership levels point to an underlying likely majority support within the proposed bargaining unit, and the union has thus met both threshold tests in paragraph 36. Lords, from that, and before I come to section 296, I turn to Article 11. Lords, this is in the electronic bundle under the Human Rights Act. For those working physically, it's tab 14. For those by page numbers, it's 1114. Lords, I know your lordships are only too familiar with the provisions of the Convention, and in particular Article 11. But it is worth just reminding ourselves of what it has to say. In subparagraph 1, it says everyone has the right of freedom of peaceful assembly and to freedom of association with others, including the right to form and join trade unions for the protection of his interests. And 2, a familiar phraseology in the Convention, but particularised in Article 11 to read, no restrictions shall be placed on the exercise of these rights other than such as are prescribed by law and are necessary in a democratic society, and for various purposes: national security, public safety, prevention of disorder or crime, protection of health or morals, or for the protection of the rights and freedoms of others, which is the phrase that my learned friends will rely on. And then this last sentence of some significance: this article shall not prevent the imposition of lawful restrictions on the exercise of these rights by members of the armed forces, of the police, or of the administration of the state. And Lords, at this stage, we simply invite the court to note 4 points from that. The first is that the right to form and join a trade union and the bundle of rights contained within that right are a particular aspect of the general right of freedom of association, which is a right shared by everyone. Secondly, the purpose of the trade union right is spelled out in the article. It is the protection of the interests of the trade unionist. Thirdly, restrictions may be imposed, but as is usual, only those necessary in a democratic society for the specified reasons. And fourthly, as your lordships have seen, the armed forces, police and state administrators all have the benefit of the right in Article 11.1, otherwise it wouldn't have been necessary to permit restrictions to be imposed on those rights by Article 11.2. So even those who are only entitled to lesser protection still have the fundamental protection of forming and joining a trade union for the protection of his interests. Lords, the approach of the domestic courts to issues not yet decided by the European Court of Human Rights, and we accept that the question of substitution clauses defeating Article 11 is not something that the European Court has ever considered, were recently set out by your lordship's court in a case cited by my learned friend Mr. Stillitz called Crown ex parte AB and the Secretary of State for Justice last year. And some of your lordships, I think, sat on that case. It's in my learned friend's interveners bundle at tab 13, page 223. Lords, and I was going to take your lordships to paragraph 53 at 247 of the bundle, 246 rather of the bundle.
246.
Page 246, my lord.
Thank you.
And the argument of the counsel for the person claiming the human rights, the appellant, is set out in paragraph 53, and I only pick up the last sentence in the judgment of Lord Reed. This, as I have explained, would be a major department from the principles currently laid down in convention jurisprudence. I don't think your lordships are concerned with what those principles in that case happen to be. But in 54, his lordship says, it is of course possible that the European Court may choose to develop its jurisprudence in this way if a suitable case comes before it. But it's not the function of this court to undertake a development of the convention law of such a substantial nature. The general approach to be adopted by domestic courts applying the Human Rights Act was explained by Lord Bingham in Ulla, expressing the unanimous view of the House. As he said, the House had previously held that courts should, in the absence of some special circumstances, follow any clear and constant jurisprudence of the Strasbourg Court. That, as he explained, reflected the fact that the Human Rights Act was intended to give effect in domestic law to an international instrument, the Convention, which could only be authoritatively interpreted by the Strasbourg Court. Accordingly, domestic courts were required to keep pace with the Strasbourg jurisprudence over time, no more, but certainly no less. Lords, those propositions are expanded in the paragraphs that follow, which I don't read, and Mr. Stillitz may well wish to address your Lordship on. But I go to the conclusion of the discussion, which is at paragraph 59 on page 248. There his Lordship says in paragraph 59, "It follows from these authorities that it is not the function of our domestic courts to establish new principles of convention law, but that is not to say that they are unable to develop the law in relation to convention rights beyond the limits of the Strasbourg case law. In situations which have not yet come before the European Court, they can and should aim to anticipate, where possible, how the European Court might be expected to decide the case on the basis of the principles established in its case law." And then he turns to the particular case. So that's the leeway allowed to your Lordships in considering, to the extent that you believe it to be so, that the European Court has not dealt with a particular issue raised in the instant case. We say the principles are absolutely clear. Lords, my next heading is that of collective bargaining. Just a few words about that. Lords, we don't put before your Lordships a classical definition of what collective bargaining is, but its nature is well understood, and we would say that a layperson's understanding is not likely to be at odds with that of an industrial relations expert. We say that the definition within the Trade Union Labour Relations Consolidation Act 1992 really captures the essence of what collective bargaining is. And this is in the electronic bundle in the same volume, if one has it physically. It's at page 672 of the electronic bundle at tab 11.
Am I right in understanding, Lord Henley, that there's more than one definition of collective bargaining?
I'm so sorry, Lord.
Am I right in understanding that there's more than one definition?
There is for different purposes,
Yes.
but the differences between them are really marginal. And for the purposes of my discussion this morning, they really don't matter at all.
Right, thank you.
Now, Lords, it's page 672. It's section 178 of the Trade Union Labour Relations Consolidation Act, subparagraph 1. In this Act, collective agreement means any agreement or arrangement made by or on behalf of one or more trade unions, one or more employers or employers' associations, and relating to one or more of the matters specified below. And collective bargaining means negotiations relating to or connected with one or more of those matters. And then your Lordship set out typical matters which are subject to collective bargaining: terms and conditions of work, physical conditions, engagement, non-engagement, termination, suspension of employment, allocation of work or duties of employment, matters of discipline, membership or non-membership of a trade union, facilities for trade union officials, and machinery for negotiation or consultation or other procedures relating to the above matters. And usefully it goes on to say recognition in relation to a trade union means the recognition of the union by an employer or two or more associated employers to any extent for the purpose of collective bargaining. Recognised should be construed accordingly. So it's a matter of fact. It's a common industrial relations term that a union is recognised, meaning that it's recognised to some extent for collective bargaining. So, Lords, that's what collective bargaining is all about. There is no convention definition of collective bargaining, but there's no misunderstanding between myself and my learned friends, we think, about what collective bargaining means. Lords, what we say about collective bargaining is that the essential feature, whether it's pursuant to the statutory recognition procedure or more generally in relation to voluntary collective bargaining, is that the requirement is only negotiation. The parties are not obliged to reach agreement, and neither domestic nor international law requires the imposition of arbitration in the event of a failure to agree. The key characteristic is that the collective agreements are reached voluntarily, even if the parties are compelled to attempt to negotiate. And if they can't reach agreement, then collective bargaining comes to an end. And my Lord, the reason, of course, that it's called collective bargaining is that it's the representation of more than one worker by the trade union. And of course, in the past, it was usually more than one employer, but nowadays collective agreements are usually confined to enterprise bargaining. In the 19th century, nearly all collective bargaining was multi-employer, either in a trade or a locality or a combination of the two, but that's neither here nor there. Lords, I turn then to Schedule A1 of the 1992 Act, which sets out the statutory recognition procedure. Lords, Schedule A1 is the only surviving statutory regulatory mechanism in England for collective bargaining. In fact, in Wales and Scotland and Northern Ireland, there are still wages councils for agriculture, Agricultural Wages Board, and of course the Welsh Agricultural Wages Board was the subject of a decision in this very court, which we needn't go into. But the distinction was that under the Wages Council's regulations, which was the negotiation was not merely compulsory, but so was the need to reach agreement. Wages councils had equal representation from unions on the one side, employers on the other, but they also had independent members appointed by government of an uneven number, so that in the event of a failure to agree between the industrial parties, a majority of those independent members would sway the vote one way or the other. They had to produce a result. That result was also a matter of law. It was put into an order by the Secretary of State and was then binding on all employers and all workers in the industry to which it related, as a matter not only of civil law but also of criminal law. All that's gone, at least so far as England is concerned. Now we only have Schedule 1. And to summarise that procedure in a sentence, we said more about it in the written case, but to summarise it in a sentence, it allows a trade union which hasn't achieved voluntary recognition from an employer to seek a declaration from the CAC that the union be recognised by the employer for the purpose of bargaining collectively, not about all the matters in Section 178, but only about pay, hours and holidays, unless they subsequently agree to expand that, in respect of a bargaining unit which the CAC will define if the parties cannot.
Where is that in the bundle?
My Lord, I'm so sorry, I should have given the reference to that. It is in the same volume. It begins at 725. I'm very grateful. And my Lords, I wasn't proposing to take your Lordships through all that. In fact, I wasn't proposing to take your Lordships to any of it. Your Lordships will see that from 725 almost to the end of that section, the Schedule A1 is set out. It's a very lengthy regime which must be fulfilled, because the only question before your Lordships is whether these riders were workers within the definition of Section 296, which is the first threshold they must surmount in order to seek statutory recognition. And that, as your Lordships have just seen, they failed to do. So in order to make an application to the CAC, the union has to fulfil various conditions. some of which your lordships have seen in the CAC judgment, sufficient membership and support in the bargaining unit, but most significantly, the workers have to fit within the definition of section 296 of the Trade Union Labour Relations Consolidation Act, which I'm going to come to in a moment. But the points we make about Schedule A1 before I do that are these. It doesn't impose any obligation on the employer to agree or to accept any terms and conditions for its workforce with which it disagrees. There's no statutory or any other requirement to submit to binding arbitration if the agreement's not reached at the end of negotiations. The legal duty to bargain collectively doesn't impinge on Deliveroo's freedom of contract. We say contrary to the assertions learned from Mr. Jean's case. The only sanction for a failure or refusal to bargain if the CAC have made a declaration is the trade union recognition method of collective bargaining order of 2000, and that, your lordships, have at tab 17 in the electronic bundle, page 1264. And at 1268, your lordships will see that it says the method specified below, the specified method, is one by which collective bargaining might be conducted in the particular and possibly rare circumstances discussed in the following paragraph. It's not designed to be a model for voluntary procedural agreements because most voluntary agreements are not legally binding, and we don't need more of that. But the next paragraph begins thus. Paragraph 31.3 provides for the CAC to impose a method of collective bargaining in cases where a union or unions, where two or more unions act jointly, has been recognised by an employer by means of an award, but the employer and unions have been unable to agree a method of bargaining between themselves or have failed to follow an agreed method. And the relevant paragraph provides for the CAC to impose a bargaining method in those circumstances only. And that prescribed method is set out at page 1271. At the foot of the page, they have to set up a joint negotiating body. That's a little earlier on, and that joint negotiating body has to conduct these negotiations for each bargaining round according to the following staged procedure. And then it sets out various steps, which I don't think I need trouble your lordships with. But the last step in the process is step 6 on page 1273. If no agreement is reached at the step 5 meeting, or the last of such meetings, within 5 working days, the employer and the union should consider separately or jointly consulting the Arbitration Conciliation Advisory Service about the prospects of ACAS helping them to find a settlement of their differences through conciliation. In the event that both parties agree to invite ACAS to conciliate, both parties will give such assistance to ACAS as is necessary to enable it to carry out the conciliation efficiently and effectively. Lord, that's it. That's the procedure. There's no sanction. There's no obligation to reach agreement. There's no method by which an agreement or a resolution to the disagreement can be imposed. So that when my learned friends talk, as they always do, about compulsory collective bargaining, they're right that it is compulsory if the CAC makes a declaration, but it means no more than a compulsory obligation to talk. And in that, it differs very much from the Wages Councils that I mentioned earlier. Of course, my lords, we accept that there are other statutory consequences to recognition beyond merely talking, such as a requirement to provide information for the purposes of collective bargaining to a recognised union, or to permit the officials of a recognised union time off with pay for trade union duties or time off without pay for trade union activities. But those obligations fall on all employers who recognise a union, whether or not it's under as a consequence of a declaration, or whether it's simply a voluntary agreement to recognise a union that the employer's undertaken. And we say that the burden is hardly a heavy one, especially if one compares to, for example, the adverse consequences to the employer of the exercise of the right to strike, which is also protected by Article 11, which may be very serious and costly indeed. So, my Lords, the most important thing we say about Schedule A1, apart from your Lordships looking at the threshold requirement, is that there is no abridgment of the employer's right to contract with its workforce on whatever terms it chooses, and there's no interference with any convention right on the part of the putative employers. Lords, my next heading is to say something about workers, about the concept of a worker. And we say the riders are properly described as workers, essentially because they work for someone else who remunerates them for so doing. Of course, we accept that that's insufficient to qualify them as what the employment law fraternity call the Limb B workers under Section 296, which is my next heading, which I haven't got there yet. But it's that's a conclusion which we don't, in relation to which we don't have permission to appeal, and I don't challenge. What is sufficient to entitle them to Article 11 rights is something that I'll come to in a moment, but it is convenient, we think, at this point to note some of the characteristics which we submit make riders workers in generic terms. And we identify 5 matters there which are significant, and we return to their significance later in the submissions. But the first is the work-wage bargain, as it's been referred to in several cases. These riders perform services for and under the direction of another person, in return for which they receive remuneration. Secondly, they are in a relationship of subordination with the person who receives the services. Now, that notion of subordination is something that we'll see in the cases in due course, particularly European Union cases, but also in domestic law cases. Subordination appears to be a relevant characteristic for the definition of worker. And the reason that we say that there is a relationship of subordination in relation to these riders is for 8 separate reasons, which I touch on briefly. First of all, Deliveroo unilaterally fixed the rate of pay. Lordships have seen that's £3.75 fee per delivery, and that Deliveroo had the unilateral right to increase the remuneration by surge pricing. Secondly, Deliveroo unilaterally fixed the mode of calculating pay. In other words, fee per delivery rather than hourly paid, or as in Battersea, a combination of hourly paid and fee per job. Thirdly, Deliveroo unilaterally fixed the intervals between the payment of remuneration, which was fortnightly. Fourthly, Deliveroo unilaterally fixed all other terms and conditions set out in the contract. And your Lordships have seen that the riders had no say whatsoever in the creation of those terms and conditions. It was simply take it or leave it. Fifthly, Deliveroo directed the work of the riders by setting the pickup and the delivery addresses. Sixthly, Deliveroo reserved the power to terminate on a week's notice a rider who was deemed too slow or for any other reason. Sixth, Deliveroo registered riders to a particular zone and reserved the power to allow riders to go out work outside that zone or other riders to work within it. And eighthly, the aspects of the engagement, the most fundamental, were set unilaterally, I've really made that point, on a take-it-or-leave-it basis. No negotiation or even consultation was permitted on either an individual or a collective basis. So returning to my 5 features, the third general feature is that the riders were integrated into the business of Deliveroo. As your lordships have seen, the CAC found that they're accurately described as the face of Deliveroo, as they're usually the only human interaction the customers have with Deliveroo. And Deliveroo described them as the very lifeblood of our company. Without them, Deliveroo wouldn't exist, a fact at the very heart of how we operate as a business. Fourthly, apart from their earnings, the riders' work is for the benefit of Deliveroo, and they share neither the chance of profit nor the risk of loss of Deliveroo's business. And finally, they occupy an unequal bargaining position. Indeed, Deliveroo ensured that they had no bargaining position whatsoever because it wouldn't bargain. So in any lay or industrial relations sense, in any generic sense, these riders were workers, and that they therefore should be entitled to bargain collectively, as clearly the members of the Court of Appeal intuitively felt. I'll come to that in due course, but Lord Justice Underhill expressed that feeling of counterintuitiveness in the result achieved by the Court of Appeal at paragraph 86, and Lord Justice Coulson at paragraph 96. And we submit that were it not for the substitution clause, there can be no doubt that the riders, through the IWGB, their union, would have been admitted to the recognition process. We think that that is absolutely clear from the decision of the CAC. So, my lords, finally I get to section 296, and this is set out at page 723 of the electronic bundle. The definition of worker and related expressions here applies to several other aspects of the Trade Union Labour Relations Consolidation Act. There is a parallel definition, not quite the same, but very close to it, for the purposes of statutory employment rights under the Employment Rights Act of 1996. But this is the 1992 Act definition. 1. In this Act, worker means an individual who works or normally works or seeks to work, A, under a contract of employment, or B, under any other contract whereby he undertakes to do or perform personally any work or services for another party to the contract who is not a professional client of his, or we don't need C, employment for the purposes of government department. And 2, in this Act, employer means a person for whom one or more workers worked or have worked or normally work or seek to work. So your lordships see there the fundamental distinction between 2.6 2961A and 2961B. 1A is a contract of employment. That is an employee with a contract of employment with an employer. And B, any other contract, including contract for services, but the requirement is to undertake to do or perform personally any work or services for another party of the contract who's not a professional client. And the reason that a professional clients are mentioned there is because 2961B actually incorporates two kinds of self-employed workers. And your lordships can see that in a decision of this court in Bates, von Winkelhoff and Clyde and Co., which your lordships have in the electronic bundle at tab 38, page 2053. Well, the facts of the case perhaps don't matter. It was a dispute in a partnership, and whether the claimant was or was not within the scope of 2961B. But I draw attention in the judgment of Lady Hale to paragraph 24, which is at page 2060. In 24, her ladyship says, first, the natural and ordinary meaning of employed by is employed under a contract of service. Our law draws a clear distinction between those who are so employed and those who are self-employed, but enter into contracts to perform work or services for others. Second, within the latter class, the law now draws a distinction between two different kinds of self-employed people. One kind of people who carry on a profession or a business undertaking on their own account and enter into contracts with clients or customers to provide work or services for them. The arbitrators in Hashwani were people of that kind. The other kind are self-employed people who provide their services as part of a professional business undertaking carried on by someone else, and a GP in Hospital Medical Group, who also provided his services as a hair restoration surgeon to a company offering hair restoration, was a person of that kind. And that distinction, her ladyship also refers to at paragraph 31, but I don't think that adds anything to it. In the case of Hashwani, the point was made again. And, Lords, I'm going to cite we haven't got Hashwani in the bundle, but the citation that I want is in your Lordship's decision in Uber, which is at page 2506. It's tab 52. It starts at page 2487, and the passage I need from Lord Legate's judgment, with which the other members of the court agreed, is 2506.
Paragraph?
Paragraph
73.
73, my lord. And his lordship is citing Hashwani and Lord Clark's judgment in it, and the quotation is at letter G, whether on the one hand the person concerned performs services for and under the direction of another person in return for which he receives remuneration, or on the other hand he's an independent provider of services who's not in a relation of subordination with the person who receives the services. Now, Lords, the difference is, of course, between the Uber driver and indeed the Pimlico plumber, as we'll see in due course, on the one hand, who are Limb B workers, and the barrister or the black cab owner-driver, known in the trade, as I understand, as mushers, on the other. They're all self-employed, but only the latter have their own businesses and clients. And that's the reason why the Lim B worker excludes those who have clients. The distinction between the two kinds of self-employment is seen in the jurisprudence of the International Labour Organization. The International Labour Organization include the self-employed as well as employees in what they say ought to be the right to bargain collectively, but it doesn't include within that right the self-employed who are in business on their own account with their own clients and customers. Well, Section 296 is the definition used in UK employment law for certain consequential rights, including trade union rights, but because of its limitations, it has had to be enlarged to accommodate Article 11 rights. And it's convenient at this point to look at the case of Crown National Union of Professional Foster Carers and the Certification Officer in the Court of Appeal, which is at page 2436 at tab 51 of the electronic bundle, decided last year in the Court of Appeal. And I draw attention to paragraph 66 at page 2458. This case concerned foster carers and whether they could form a trade union and have it listed by the certification officer who lists all the independent trade unions in the country. And in order to form a trade union or have it listed, it's again necessary to satisfy the requirements of Section 296. And the question was whether foster carers fell within the definition of 296. And the problem that they had in paragraph 66 is that because of an earlier Court of Appeal decision, a W and Essex County Council, foster carers don't provide their services under a contract, and accordingly they're not workers for the purposes of the 1992 Act. We're thus concerned only with whether their consequent exclusion from the right to be listed under the relevant section of the 1992 Act would give rise to a breach of their rights under Article 11. So that was the problem.
Which paragraph was that? Which paragraph have you just read?
I was at paragraph 66, my Lord.
66, thank you.
I'm so sorry.
Not my fault. Thank you.
So because they didn't have a contract, they couldn't fall within Section 296. So the question was whether Article 11 redressed the balance. And your Lordships will see that the Court of Appeal, Lord Justice Underhill, dealt with Article 11 at paragraph 72, and in particular at paragraph 74, whether a convention right is engaged. Now, if I may, I read this now, even though we haven't got to the issue of Article 11 yet, or at least the authorities on it. The question whether a convention right is engaged may mean rather different things in different contexts. In this context, what it refers to is whether foster carers working under the non-contractual arrangements outlined above fall within the scope of Article 11, or to put it another way, whether Article 11 rights extend to them. It's common ground that the definition of worker as a matter of domestic law can't be determinative of that question. Parties will agree the starting point was the case of Sindicatul Pastoral Salbun in Romania, the Good Shepherd case, and we're going to come to that later, so I don't deal with it now. Over the page at paragraph 78, in their discussion of the Good Shepherd case, the Court of Appeal dealt with ILO recommendation number 198. We have to come to that to in due course, so I don't deal with it now. But at paragraph 88, they deal with the question of remuneration and so on. At 89, the argument was that, or the first of the arguments made for the certification officer was that the essential character of foster care was familial and caring and not occupational. Provision of foster care is not an economic activity. And Your Lordship sees the rest of 89. And at paragraph 90, Lord Justice Underhill says that the submission has force and it's given me some pause, but in the end I don't accept it. I quite accept the role of foster carer has the special features relied on by the respondents, but I don't believe that those features are inconsistent with the existence of an employment relationship in the sense necessary to engage the Article 11.1 right. And accordingly, at 95, the Court of Appeal say, I'd accordingly conclude that all foster carers who undertake placements under the regulations should be regarded as being during a placement in an employment relationship with the fostering service for which they undertake that placement, such that Article 11 of the Convention is engaged. I don't need more than that, but at 107, yes, I don't need 107 or 108, but in 111, His Lordship says, I don't accept the submission on behalf of the Secretary of State that the refusal to list was not an interference. He says, I don't accept that submission. In my view, the fact that the union is precluded from applying for recognition under Schedule A1 constitutes an interference with its Article 11 rights, as from the moment of the refusal to list, it can't be right that in order, and so on. Lords, in that case, consequently, and I'll deal with it now so I don't have to come back to it, the Court of Appeal read down Section 296 in order to give effect to their judgment. And the reading down passage is at 2482 of the judgment. At 143, His Lordship sets out the Section 3.1 of the 1998 Human Rights Act and turns to Gillam and the Ministry of Justice. I take it from the last couple of sentences, or the last sentence of 144, went on to hold that it was possible to read down the statutory definition so extended to an employment relationship of the kind found to exist in O'Brien. As noted in paragraph 81, the language of employment relationship in O'Brien derived from the Part-Time Workers Directive, but it plainly has the same meaning as the Good Shepherd. If, therefore, as I would hold, foster carers are in an employment relationship for the purpose of Article 11, it must follow that the term worker in 2961 can equally be read down so as to include them, notwithstanding that they don't work under a contract. And Your Lordship see what Baroness Hale said about that. So the Court of Appeal didn't alight on a particular formula of words, but simply declared that the Section 296(1) had to be read down in order to accommodate the requirements of Article 11. Lords, from that, and still under my heading of Section 296, Your Lordships will have seen that personal service is the issue in the instant case. It's required in Section 296, as in the similar but not identical definition for most employment rights in Section 230 of the Employment Rights Act. But personal service is not a requirement for other definitions of worker. And we've given one in our case, the definition for whistleblowers. I needn't take your lordships there, but it's Section 230, subsection 6 of the Act, which your lordships have at page 1099 of the bundle, which for the purposes of public interest disclosure protection, the whistleblower protection, doesn't require that a worker provides personal service. Lords, we found another example as well in the National Minimum Wage Act.
I'm so sorry, can you give me the page number for the one you've just referred to?
Yes, it's 1099, my Lord.
Thank you.
The definition in the National Minimum Wage Act at section...
Isn't that because it's limited to Lim A people?
That definition?
At page 1098.
Your Lordship, your Ladyship...
Actually, your Ladyship. It's Lady Rose.
Lady Justice, I'm so sorry.
No, I'm not Lady Justice Rose, I'm Lady Rose.
Forgive me, my lady.
You have ignored me so far this morning in your submissions, even though I assume you want me to take them into account.
Of course, my lady. I'm so sorry. I didn't mean to cause any offence at all. I can only apologise. It's unforgivable. Lady, can I return to that issue later? I'm getting a bit anxious about the time now. Lady, it may be a very powerful point, but these other examples are really neither here nor there, and I'm going to leave them for the moment, if I may. The question then is whether a right of substitution defeats the requirement of personal service in UK law. The leading authority on this is Pimlico, Plumbers and Smith in this court. It's at page 2225 at tab 45 of the 2225, which is tab 44 of the bundle. This concerned a plumber who worked for Pimlico Plumbers Limited. The facts are set out in the headnote. Various features arise. Lords, I'm going to take your lords, my lords and my lady, to Lord Wilson's judgment, which is at paragraph 22 at page 2234. At paragraph 22, Lord Wilson cites the well-known case in employment law of ready-mix concrete in 1968, which the judgment of which includes the word freedom to do a job either by one's own hands or by another's is inconsistent with the contract of service, though a limited or occasional power of delegation may not be. He cited a tire's vicarious liability in which it was stated, seems reasonably clear that an essential feature of a contract of service is the performance of at least part of the work by the servant himself. And court will see that paragraph 24, there was no express right to appoint a substitute, but at paragraph 25, the tribunal found that Smith did have a limited facility to substitute. And at the end of that paragraph, his lordship says, I will assume, without deciding, that it is the product of a contractual right. And at 27, at the top of page 2236, the court can, in my view, be confident that the tribunal found it was entitled to find that Mr. Smith's only right of substitution was of another Pimlico operative, such as the judge's express finding both in the central part of her judgment and again in her conclusion. So the question becomes, was Mr. Smith's right to substitute another operative inconsistent with an obligation of personal service? It's important to note the right was not limited to days when, by reason of illness or otherwise, Smith was unable to do the work. His own example of an opportunity to accept a more lucrative assignment elsewhere demonstrates its wider reach. And at 33, Lord Wilson examines the terms of the contract, noting at the foot of 2237 the vocative words clearly showing that the requirements are addressed to Mr. Smith personally. And at 34, the tribunal was clearly entitled to hold, albeit in different words, that the dominant feature of Mr. Smith's contracts with Pimlico was an obligation of personal service. To the extent his facility to appoint a substitute was a product of contractual right, limitation of it was significant. Substitute had to come from the ranks of Pimlico operatives, in other words, from those bound to Pimlico by an identical suite of heavy obligations, converse of a situation in which the other party is uninterested in the identity of the substitute, provided only that the work gets done. Tribunal entitled to conclude that Mr. Smith had established that he was a Limb B worker unless the status of Pimlico by virtue of the contract was that of a client or customer of his. So, Lords, we take from that
definition of a dominant feature. How do you apply the concept of a dominant feature in practice?
Well, that's the question, my Lord. It's not developed in the judgment in Pimlico plumbers. It has to be a matter of impression, taking into account all the factors, all the features of the particular employment.
We're concerned with Article 11 alone. We're not concerned with Section 296.
Absolutely,
and so this is an interpretation of Section 296.
Indeed, my Lord.
Does this come into effect at all in relation to Article 11?
Only in this way, my Lord. Only in this way, that it establishes, even where there is substitution, that even under the UK law, which specifically requires personal service.
What's UK law got to do with the autonomous concept of a worker?
Well, Lord, all we say about it is that if UK law, with its particular requirement of personal service, permits a substitute where a personal service is a dominant feature, Article 11, with its much broader scope, and bearing in mind that any limitations on the rights must be interpreted restrictively, must likewise permit a substitute. It can't be the case that the European Court of Human Rights would be more restrictive than UK law with its specific requirement of personal service. That's all we can take from it. We're not seeking to argue Section 296 applicability to the riders in this case. Of course, we don't have the right to appeal on that issue. All we do is to draw attention to the fact that substitution doesn't necessarily, even in the UK restrictive legislation, defeat personal service.
Lord Hendy, can you help me on this, please? I don't at the moment understand why ECHR law could not be more restrictive than English.
Lord, for reasons that I'll come to when we look at the case of Damir and Turkey, that there's no reason theoretically, of course, that must be the case, but the purpose of Article 11 in particular is to protect the interests of trade unionists. That's spelled out in express terms, and the court have held that any restrictions on that right, any limitations on that right, must be construed restrictively. So we would say that points to a broader perspective from the European Court than under domestic legislation. But I accept what your Lordship says. There's no intrinsic reason why it couldn't be more.
So your point really is that the effect of Demir and other authorities is that the position is the same in ECHR law.
Well, Lord, we doubt that it can be the same, but it may be.
That it permits substitution.
Oh, I'm with you. That it would permit.
You're seeking to derive something from the position in domestic law. But I think your point actually is no more than that your submission is supported by authorities in Strasbourg.
Well, indeed, it's probably a very small point. Perhaps I shouldn't have spent time on it, but all I was endeavouring to say is that even under the restrictive regime of 296, substitution is permitted.
Yes, thank you.
Well, I thought there was another point that could potentially be taken out of Pimlico, and that is at paragraph 32, towards the end of the paragraph, Lord Wilson says the sole test is, of course, the obligation of personal performance. Any other so-called sole test would be inappropriate usurpation of the sole test.
Yes.
And my understanding, and correct me if I'm wrong, is that you say that under Article 11 there is no sole test.
That's correct. Yes.
But you haven't issued a notice of incompatibility, as far as I understand.
No, Lord, because we submit that 296 can be read down to accommodate Article 11.
And how would you do that?
Oh, well, may I come to that later on at the close of the submissions. But my Lords, of course, my learned friends would point to that the words of the statute are the sole test, but your Lord, my Lords, my Lady, will observe that passage precedes Lord Wilson in paragraph 34, saying that the dominant feature it was sufficient. Anyway, I've laboured too long on Pimlico plumbers. I need to move on. Lords, at this point I was intending to take your Lordships to the contract itself, just to draw attention to its provisions. It's at 296 of the electronic bundle at tab 9.
This is the new contract.
This is the new contract, Lord, but it was the one that was considered by the CAC. Lords, first of all, I just draw attention to the fact the use of the vocative throughout this. Everything is you, and the last sentence of B, although making provision for personal service or somebody else engaged by you, the last sentence says, should you choose to provide services through a third party in this way, you remain responsible for ensuring that the obligations set out in this agreement are complied with. 2.2 sets out the nature of the services that we've already seen, and paragraph 2 sets out provisions which the CAC have already, the CAC passages I've drawn attention to have already summarised. Lords, I turn to paragraph 5, warranties, which says in 5.1, as strict conditions of the agreement, you warrant upon commencement and continuously throughout the terms of the agreement that, and then it sets them out. Right to reside and work, necessary visas, license, permits, no unspent convictions, comply with all other legal obligations, including the Highway Code, and to allow customers to track progress, GPS technology. Insurance, they have to obtain, and substitutes needn't have their own insurance as long as they're covered under your insurance. Liability, you acknowledge and agree that you and not any substitute are responsible for the provision of the services if and when undertaken. You accept liability for any losses suffered by a deliverer as a result of negligent provision, and then the right to appoint a substitute, the right without the need to obtain deliverer's prior approval to arrange for another courier to provide services in whole or part on your behalf. It may not include an individual who's previously had their supplier agreement terminated by Deliveroo for a serious or material breach contract, or who, while acting as a substitute, whether for you or a third party, has engaged in conduct which would have provided grounds for such termination had they been a direct party to a supplier agreement. For substitute, use a different vehicle, you have to notify your responsibility to ensure your substitutes have the requisite skills and training, and to procure that they provide the warranties at clause 5 above to you for your benefit and for Deliveroo's benefit. And a line below, you will continue to bear full responsibility for ensuring that all obligations under this agreement are met. All acts and omissions of the substitute shall be treated as though those acts or omissions were your own. And then the termination provisions, your Lordship sees it, and Ladyship see it, paragraph 10, data protection, use of a smartphone and so on, and compliance with various laws, and 13.3, agreement personal to you may not be assigned to a third party. And my lords, my lady, we can turn away from that contract. There are a number of features of this case which we say, to the extent that personal service is necessary in relation to Article 11, personal service remains a dominant feature of the rider's contract. We've set it out in our case at paragraph 120 to 121, key documents 56 to 57, but perhaps I could just outline a number of features. First of all, personal service was the normality. As your Lordships and Ladyship have seen, few riders have failed themselves of the right of substitution, which was therefore irrelevant to the vast majority.
To what extent is it appropriate, Lord Hendy, for us to have regard to the way in which the contract may normally have been performed as opposed to the contractual provisions of performance?
Well, my Lord, that is a significant question. We say that the European Court of Human Rights would take a realistic view of this and look at how the clause operated in practice. Indeed, since the Uber case in this court, a more realistic view of or put it another way, the contract is no longer the dominant feature, as it were. It's the statute that the court must have regard to. But equally, under Article 11, the European Court is going to look at the case in a realistic way and not be confined to the particular contractual requirements. Now, whether that would be enough, we would submit that it's certainly a relevant factor, but I can't point to any jurisprudence from the European Court saying that that's the way to look at it.
Yes, Uber was a case on domestic law.
It was indeed, my Lord.
You say it may be relevant by analogy.
By analogy, indeed. Well, we say it's consistent with the way the purposive construction which the European Court has adopted.
Thank you.
Well, that was the first point. Personal service is the normality. Second point is that the substitute retained personal responsibility for the substitute carrying out the job, as your lordships have seen. Thirdly, Deliveroo didn't know whether a rider or a substitute was carrying out the job, but what they did know is where the app was so that they could track what was being done, which remained the responsibility of the rider, and in respect of which the rider would be paid. Next, there were contractual limitations on the exercise of the right of substitution, as my lords and my lady have seen. I don't develop those further. And there were some limitations on the characteristics of the substitutes who could be possibly engaged. See paragraph 8.2. And ultimately, the pricing structure made it not worthwhile to engage a substitute, as the vast majority of riders see no point in engaging a substitute, as the CAC said at paragraph 79. And finally, the substitution clause was a term imposed by Deliveroo and not sought by the riders and was non-negotiable.
Does the contract actually say that the substitute has to have Deliveroo training?
It said had to have the requisite skills and training.
It's in the footnote at page
Yes,
7.
and in consequence of that, we say that it's got to be either training delivered by Deliveroo or the rider delivering equivalent training to the substitute, which seems a bit remote. I mean, the idea of the rider being able to subject the substitute to endless multiple question tests seems unlikely, but that wasn't explored further.
Thank you.
So we say, to the extent that personal service is a relevant consideration in eligibility for trade union rights in Article 11, the riders did undertake sufficient personal service. Certainly the features of their employment put them in the category of an employment relationship, or one closely akin to it. And with that, I turn next to the European Court of Human Rights authorities, beginning with the case of Damir and Beikara, which your lordships have at page 2888, 2888, which is tab 62 of the bundle. Well, forgive me, I keep saying your lordships, and I don't mean to be disrespectful. I must say the court in future. Forgive me. The court will see in Damir at 288 that the issue for the head note was that a local authority union entered into a collective agreement with a local authority, and this was quashed by the courts in Turkey, because it was said at the end of the first paragraph, any union so formed had no authority to enter into collective agreements as Turkish law stood. So the matter progressed to the European Court of Human Rights. And at page 2893, at paragraph 37, court will see that the Grand Chamber considered, first of all, international law universal instruments, beginning with ILO Convention 87 on freedom of association, protection of the right to organise. At 39, they took into account the jurisprudence of the Committee on Freedom of Association of the ILO. At 40, the International Covenant on Civil and Political Rights. At 41, the International Covenant on Economic, Social and Cultural Rights. At 42, ILO Convention number 98 concerning the application of principles, the right to organise and to bargain collectively. At 43, jurisprudence of the ILO Committee of Experts. At 45, the European Social Charter, Article 5, the right to organise, and at paragraph 49, Article 6, the right to bargain collectively. All this material is set out, of course, in our written case. And at 50, the jurisprudence of the European Committee on Social Rights, the supervisory body for the European Social Charter. At 51, the European Union Charter of Fundamental Rights, and at 52, the practice of European states. In paragraph 65, if I can go there, they're dealing with the Chamber judgment, which preceded the judgment of the Grand Chamber. It's 65, in the middle of that paragraph, it said that in accordance with the Vienna Convention, the court is required to ascertain the ordinary meaning to be given to the words in their context and in the light of the object and purpose of the provision for which they are drawn. And that is the basis of the purposive construction which the European Court must apply to Article 11 and the other articles. At 66, they say, since the Convention is first and foremost a system for the protection of human rights, the Court must interpret and apply it in a manner which renders its rights practical and effective, not theoretical and illusory. At 67, it has to take into account any relevant rules and principles of international law applicable in relations between the contracting parties. At 68, it's always referred to the living nature of the Convention, which must be interpreted in the light of present-day conditions, and that it has taken account of evolving norms of national and international law in its interpretation of Convention provisions. And at 69, another reference to the international treaties that are applicable in the particular sphere. At 74, talks about the Council of Europe instruments, such as the European Social Charter, and likewise at 75. The consideration by the court at 76 is material. Sadi confirmed that when the court considers the object and purpose of the Convention provisions, it also takes into account the international law background to the legal question before it, being made up of a set of rules and principles that are accepted by the vast majority of states. The common international or domestic law standards of the European states reflect a reality that the court cannot disregard when it's called upon to clarify the scope of a convention provision, that more conventional means of interpretation have not enabled it to establish with a sufficient degree of certainty. And at 78, the court observes in this connection that in searching for common ground amongst the norms of international law, it has never distinguished between sources of law according to whether or not they've been signed or ratified by the respondent state. And at 85, the conclusion is expressed that in defining the meaning of terms and notions in the text of the Convention, court can and must take into account elements of international law other than the Convention, the interpretation of such elements by competent organs, and the practice of European states reflecting their common values. The consensus emerging from specialised international instruments and from the practice of contracting states may constitute a relevant consideration for the court when it interprets the provisions of the Convention. Not necessary for the respondent state to have ratified the entire collection of instruments that are applicable, sufficient for the court, the relevant international instruments denote a continuous evolution in the norms and principles applied in international law or in the domestic law of the majority of member states of the Council of Europe, show in a precise area there's common ground. And at 96, there's reference to the three categories of worker at the end of subparagraph 2 of Article 11, and at 97 the court says, in this connection it considers the restrictions imposed on the three groups mentioned in Article 11 to be construed strictly and should therefore be confined to the exercise of the rights in question. These restrictions must not impair the very essence of the right to organise. And a few lines further on below, the Council of Civil Service Unions says, moreover, in the court's view, it's incumbent on the state concerned to show the legitimacy of any restrictions to such persons' right to organise. Lords, if that applies to those three categories on which restrictions are permitted, it applies more strongly to those on whom restrictions are not spelt out as being permitted. 109 over the page, the court reiterates that Article 11 presents trade union freedom as one form or a special aspect of freedom of association. At 110, although the essential object of Article 11 is to protect the individual against arbitrary interference by public authorities with the exercise of the rights protected, there may in addition be positive obligation on the state to secure the effective enjoyment of such rights. And at 111, the court will see that they deal with compliance with Article 11, and at 119, necessity in a democratic society. And my lords, my lady, will see there that the court says in the middle that there's only a limited margin of appreciation, but that's an issue which I'm going to come to later.
Whereabouts in its decision does it use the international conventions they've set out?
Yeah, it does, my lord, yes.
Whereabouts does it do that?
My lords, having set them all out, I'm going to come in a moment to paragraph 153 and 154, which are the key to this decision. But before I get there, can I just draw attention to paragraph 140 on evolution of the case law. So the development of the court's case law concerning constituent elements of the right of association can be summarised as follows. Court has always considered that Article 11 of the Convention safeguards freedom to protect the occupational interests of trade union members by the union's collective action, the conduct and development of which the contracting states must both permit and make possible. So your Lordship see the force of that.
That is paragraph?
That's 140, my Lord.
Thank you.
At 2902. 144. As the result of the foregoing, the evolution of case laws to the substance of the right of association enshrined in Article 11, marked by two guiding principles. Firstly, Court takes into consideration the totality of the measures taken by the state concerned in order to secure trade union freedom, subject to its margin of appreciation. Secondly, Court does not accept restrictions that affect the essential elements of trade union freedom, without which that freedom would become devoid of substance. These two principles are not contradictory but correlated. This correlation implies that the contracting states in question, whilst in principle being free to decide what measures it wishes to take in order to ensure compliance with Article 11, is under an obligation to take account of the elements regarded as essential by the Court's case law. Following essential elements can be established, and it sets out those that's established so far. 146, the list is not finite. On the contrary, it's subject to evolution depending on particular developments in labour relations. In this connection, appropriate to remember, conventions are a living instrument which must be interpreted in the light of present-day conditions and in accordance with developments in international law, so as to reflect the increasingly high standard being required in the area of protection of human rights, thus necessitating greater firmness in assessing breaches of the fundamental values of democratic societies. In other words, limitations to rights must be construed restrictively in a manner which gives practical and effective protection to human rights. They consider the right to bargain collectively at 147. That refers to ILO Convention 151 at 148 and European Social Charter at 149 and other matters, and then comes to the concluding paragraphs 153. In the light of these developments, the Court considers that its case law to the effect that the right to bargain collectively and to enter in collective agreements does not constitute an inherent element of Article 11 should be reconsidered so as to take account of the perceptible evolution in such matters in both international law and domestic legal systems. While it is in the interest of legal certainty, foreseeability and equality that the Court should not depart without good reason from precedents, a failure by the Court to maintain a dynamic and evaluative approach would risk in rendering it a bar to reform or improvement. 154. Consequently, Court considers, having regard to the developments in labour law, both international and national, and the practice of contracting states in such matters, right to bargain collectively with the employer, has in principle become one of the essential elements of the right to form and join trade unions for the protection of one's interests set forth in Article 11. It being understood that states remain free to organise their system as, if appropriate, grant special status to representative trade unions. And the consequence was that there was interference with the applicant's trade union freedom by striking down the collective agreement. That's at 157. So, Lords, that's the fount of the origin of the right to bargain collectively. The right was also considered in Unite the Union and the United Kingdom, but given the time, I'm not going to take your Lordships there, but for your Lordships' margin, it's 3040 of the electronic bundle at tab 69. And there it was held that this was a challenge to the abolition of the Agricultural Wages Board, and the Court held that the state's positive obligations under Article 11 didn't extend to providing a mandatory statutory mechanism for collective bargaining. That's in paragraph 60 at 3046 and 65 at 3047. Lords, in our written case, we've referred to two cases which I'm not going to trouble your Lordships with this morning. The first is Sigurd Jonsson and Iceland, which concerned self-employed taxi drivers. It's at page 2765 at tab 59. All I say about that is that the claimant, the applicant, was seeking to establish a trade union. The Commission regarded that as an Article 11(1) matter. It went from the Commission to the European Court, but the European Court felt it not necessary to decide if it was a trade union case, holding that it was sufficient to regard it as a freedom of association case. That's at paragraph 32 of the judgment at 2780. So I don't think that takes matters much further. Neither does the case of Olafsson, which we refer to in our written case, which is at page 2908, tab 63. Again, it's essentially a freedom of association case. So I can now turn to the case of the Good Shepherd Syndicatal Pastoral Cell Bun, which your lordships have in the electronic bundle at 2938, which is tab 64. This was a group of priests in Romania who were seeking to establish a trade union. The facts have some materiality, and I take your lordships to page 2945, and your lordships will observe. Your lordships and your ladyship will observe in paragraph 30 to 32 that the priests were not paid by the bishopric but by the state at a rate which was proportionate to state school teachers. They were subject to a church statute, that's at paragraph 41, and from that one sees that the priests serve the diocese rather than the bishop. Originally, they were considered to be employees, but that was changed, and one can see that at paragraphs 43 and 44, so that the contracts of employment were replaced at the bishop's instigation with appointment decisions issued by him. So there was no contract of employment consequently. Their trade union apparently intended to bargain collectively if it could. I take your lordships and your ladyship to pay paragraph 139 at page 2945.
Page
No.
2954. 2954. Paragraph 139. So the question was whether their status as members of the clergy, the applicant union members are entitled to rely on Article 11, and whether the refusal to register the union impaired the very essence of their freedom of association. Paragraph 141, it's not the court's duty to settle the dispute between the union's members of the church hierarchy concerning what their duties were, but the Grand Chamber in 142 will apply the criteria laid down by the relevant international instruments, see Mutatis Mutandis, Damir and Becara, and they refer in particular...
Sorry, Henry. The last part of paragraph 141 seems to connect the right to form a trade union with an employment relationship.
Absolutely, my lord. And that's the question that they address in the following paragraphs.
Yeah. And so you accept that the right to form a trade union isn't open to everyone. It's a right open to those in an employment relationship.
Well, my lord, we say that the European Court puts it more broadly than that. The use of the phrase employment relationship is clearly a shorthand, and we say it's a shorthand for the purposive exercise of determining what is necessary for the protection of the rights of the trade union members in question. But I'll come to that in a moment.
Before I leave it, do you accept there has to be an employment relationship of some form or other before you have a right to form or join a trade union, as opposed to that right being available to everyone?
I do accept, my lord. of some form or other. The question is, how broad is that formulation? It's clearly not restricted to those with a contract of employment. It's broader than that.
Yeah.
The ILO material suggests it includes self-employed. And your lordships will see in a moment that the decision in this case is not that the priests were employed, but simply that they were in what it termed an employment relationship, or rather in the context of an employment relationship. That's the phrase that's used. So your lordships see in 142 the material that they took into account, in particular ILO Convention number 87, which protects the right to organise and so on. And then at 143, they say the court observes that the duties performed by members of the trade union in question entail many of the characteristics, features of an employment relationship. For example, discharge of activities on the basis of a decision by the bishop appointing them, setting out their rights and obligations. Under the bishop's leadership, they carry out tasks assigned to them, besides performing liturgical rites and maintaining contact with parishioners, teaching, management of parish assets, also responsible for the sale of liturgical items and so on. I don't read further into that paragraph. Admittedly, at 144, particular feature of the work of members of the clergy is that it also pursues a spiritual purpose carried out within a church enjoying a certain degree of autonomy, bound by a heightened duty of loyalty, itself based on personal and in principle irrevocable undertaking by each clergyman. May therefore be a delicate task to make a precise distinction between the strictly religious activities of members of the clergy and their activities of a more financial nature. However, the question to be determined is rather whether such special features are sufficient to remove the relationship between members of the clergy and their church from the ambit of Article 11. In this connection, the court reiterates that paragraph 11.1 presents trade union freedom as a form, special aspect of freedom of association. Paragraph 2 doesn't exclude any occupational group from the scope of the article, that most national authorities entitled to impose lawful restriction, and so on. And at 148, so far the court's looked at factors pointing one way and factors pointing the other. And at 148, having regard to all the above factors, the court considers that, notwithstanding their special circumstances, members of the clergy fulfil their mission in the context of an employment relationship falling within the scope of Article 11. Article 11 is therefore applicable to the facts of the case. Grand Chamber agrees with the parties. The refusal to register is an interference with Article 11. Now, on the facts of that particular case, that interference was justified by reference to Article 11.2, because it was said a trade union would interfere with the autonomy of the church. But the case is clearly an important one to give guidance as to the scope of those who can claim the protection of Article 11.1. So, my lords, what's clear then is that what one is looking for is something in the context of an employment relationship, but it's certainly not confined to employment, because these priests were not employed by anybody. ILO recommendation 198 was referred to, as your lordships have seen in that judgment. The court actually set out many of the provisions of it at paragraph 57 and 58, 57 rather, 2947, but we have the recommendation itself in the bundle, and the court will find that at 2950. 3147. Paragraph at divider 57.
2947.
Hang on, I've got the wrong. Sorry? 3135, I'm sorry.
Sorry, 3135, did you say?
3135, yes.
Thank you.
Sorry.
Yes.
There's tab 79 for those that are using that system. Well, so just draw attention to certain passages within it. In the preamble, if your lordships and your ladyship go halfway between the hole punches, the 1, 2, 3, 4, 5th provision is considering that employment or labour law seeks, among other things, to address what can be an unequal bargaining position between parties to an employment relationship, and considering the protection of workers is at the heart of the mandate of the International Labour Organization in accordance with the principles set out in the ILO Declaration on Fundamental Principles of Rights at Work and the Decent Work Agenda, and considering difficulties of establishing whether or not an employment relationship exists in situations where the respective rights and obligations of the parties concerned are not clear, where there has been an attempt to disguise the employment, or where inadequacies or limitations exist in the legal framework or in its interpretation or application, and noting that situations exist where contractual arrangements can have the effect of depriving workers of the protection they are due, and recognising that there's a role for international guidance for members in achieving this protection through national law and practice, and that such guidance should remain relevant over the time, and so on. They then set out guidance for member states, and that's on the next page at 3136, which invites member states to formulate and apply a national policy for reviewing the scope of relevant laws and regulations in order to guarantee effective protection for workers who perform work in the context of an employment relationship. And that's where the phrase adopted by the European Court of Human Rights, in the context of an employment relationship, emanates. 2, the nature and extent of the protection given to workers in an employment relationship should be defined by national law or practice, or both, taking into account the relevant international labour standards. 3, should be formulated and implemented in consultation with the social partners, and the determination of the existence of an employment relationship is the heading across the page. 9 says, for the purposes of the national policy of protection for workers in an employment relationship, determination of the existence of such a relationship should be guided primarily by the facts relating to the performance of work and the remuneration of the worker, notwithstanding how the relationship is characterised in any contrary arrangement, contractual or otherwise. So the first guide is performance of work and remuneration of workers, regardless of a contract. 11, members should, within the framework of the national policy referred to in this recommendation, consider the possibility of the following: A, allowing a broad range of means for determining the existence of employment relationship; B, providing for a legal presumption that an employment relationship exists where one or more relevant indicators is present. And that we submit as an important feature of this recommendation. 12 says members may consider clearly defining conditions for determining the existence of employment relationship, for example, subordination or dependence. 13, members should consider the possibility of defining in their laws or regulations by other means specific indicators of the existence of an employment relationship. Those indicators might include, and then there are a whole list of them, work carried out according to the instructions under control of another party, satisfied in the instant case, involves the integration of the worker in the organisation of the enterprise, satisfied in the instant case, performed solely or mainly for the benefit of another person, satisfied in this case, must be carried out personally by the worker. Query, is that satisfied in this case? Carried out within the specific working hours or at workplace specified or agreed by the party requesting the work. Yes, once an order is accepted, it must be carried out at the places specified. Particular duration, certain continuity, perhaps yes, perhaps no. We know that the speed of delivery was important. Requires the worker's availability, not satisfied. Involves the provision of tools, material, machinery by the party requesting the work, not satisfied. Over the page, periodic payment of remuneration. Yes, that was satisfied if they'd earned fees per delivery. Fact that such remuneration constitute the worker's sole or principal source of income. Yes, it did for many, but not all, but that's true of ordinary employment too. Provision of payment in kind, not relevant. Recognition of entitlements such as weekly rest and annual holidays, no, not recognised. Payment by the party requesting the work for travel, not applicable. Absence of financial risk for the worker, yes, that was applicable. They took no risk in the success or otherwise of Deliveroo, and neither were they conducting a business of their own. So some factors were present and some were not in the circumstances of this particular case, but your lordships will and your ladyship will have observed that there should be a provision. The recommendation is for legal presumption if one or more relevant indicators are present, and the primary guide will be performance of work and remuneration, which most certainly were satisfied in this case. So, my lords, turning from that, I can go to I think the last case under Article 11 to which I need draw attention, which is the case of Manole and Romanian Farmers Direct in Romania, which is at tab 67 at page 3009 in the electronic bundle. It's a curious case, and at page 3012 in paragraph 6, the court will see that a farmer and 48 other persons decided to form a trade union called Agricultural Trade Union Romanian Farmers Direct. And in paragraph 8, according to the statutes of the union, the applicant trade union's main purpose was to defend the interests of its members. That's to say, farmers and persons providing services for farmers, including transport facilities. And it sets out the first purpose there. At paragraph 13, we see that the local court, the domestic court, accepted the appeal, observing that only employees holding a contract of employment and civil servants could set up trade unions, to the exclusion of farmers and other self-employed persons who could only join existing trade unions, a curiosity of Romanian law. The European Court then considered, as they do in all these cases, the International Labour Organization material. That's at page 3014, paragraphs 23 and so on, including a reference to a decision of the Committee of Experts and an ILO publication, which in paragraph 82 of the internal pagination, says the ILO's supervisory bodies have consistently emphasised that all workers, without any distinction, and in respect of their employment status, including self-employed workers, managerial and workers in cooperatives, should enjoy the right to establish and join trade unions of their own choosing, like all other workers. And in 158 of that declaration, second line, in many countries, agricultural and rural workers are still denied the right to organise and bargain collectively. And that paragraph concludes agricultural workers should have the same rights, association and combination as industrial workers, but in 159 there are practical difficulties. The court cited ILO Convention number 141 on rural workers' organisations, not relevant in our own case, but nevertheless perhaps indicative of why they treated this as a trade union case. Article 2.1. Term rural workers mean any person engaged in agricultural, handicrafts or related occupation in rural area, whether as a wage earner or subject to the provisions of paragraph 2. As a self-employed person such as a tenant, sharecropper or small owner occupier. Convention applies to tenants, sharecroppers and small owner occupiers who derive their main income from agriculture, work the land themselves, help only their families or with the help of occasional outside labour, and who do not permanently employ workers, employ a substantial number of seasonal workers, or have any land cultivated by sharecroppers and tenants. And in the next paragraph, they should have the right to join organisations of their own choosing. Laws, I won't read more from that.
Who were they seeking to negotiate with? Was this for the price that they received for their produce rather than?
It appears to be, although I think their purpose was a little wider than that, lady. That all we can deduce is in paragraph 8. But it does say it appears that the desire was to help Romanian farmers move on from subsistence farming to agriculture as practiced in the European Union. So produce directed towards the market rather than self-sufficiency.
But it doesn't seem to have been about negotiating wages.
No, it doesn't. It doesn't have the typical collective bargaining feature that one would expect, lady.
What is your, the ILO recommendation that you showed us, that doesn't set any particular definition of the employment relationship. It says these are all the factors you might want to consider when you're deciding in your own legislation what it's going to be.
Absolutely.
But as I think Lord Justice Underhill pointed out in the Court of Appeal in this case, when the Strasbourg Court or when this court gets to grips with that, they have to decide what is the definition going to be. So where do you say we find what the Strasbourg Court drew from the ILO recommendation suggestions as being what was the test for the application of Article 11?
Yes.
And how does that affect the validity of the test in Section 296, which seems to focus on one rather than a sort of selection of indicators? I think that's what I'd like to hear submission.
Yes. Lady, that must be so. 296 does focus really, in the context of this case, on that particular feature of personal service, but the ILO recommendation includes that amongst a whole number of other indicators. all we can deduce from the Good Shepherd case is that the European Court has regard to that ILO recommendation, but didn't consider that it was bound by any particular definition of an employment relationship, although it did proceed on the basis that an employment relationship would be a sufficient basis to claim Article 11 rights. But what we say about the Court of Appeal is that the Court of Appeal seems to have focused on personal service as a precondition of a protection of Article 11, and that's simply not justified when one examines the Good Shepherd. In fact, we go further than that. We say that as the court is looking towards the future and speculating, if I can put it that way, as to what the European Court might find were this case to come before them, the European Court would take a broader approach and look at the purpose of the protection which these riders through their union are seeking to gain, to see whether, in seeking that protection, they fall within the ambit of Article 11.1.
But is it your case that one can draw from the Good Shepherd and from Manoli that our domestic provision is incompatible with Article 11 because of its focus on that single factor? Because what the European Court said is, having regard to the ILO suggestions, what we decide as being the scope of Article 11 is that you must, O contracting states, look at a range of factors and not focus on one. Is that what your case is?
Yes, my lady. Yeah, we do say that. Yes, we do say that there's an incompatibility in section 2961B as it's applied for the purposes of admission to the threshold of the Schedule 1 procedure. It is incompatible, and this case shows that this group of workers should not have been shut out had Article 11.1 taken precedence. I mean, that's the substance of our appeal, at least on the first
So then
round.
You say the imposition in the domestic law of that single indicator, or the limitation of the investigation to that single indicator, in effect operates as a restriction on the right of people who come within the scope of Article 11, even though they don't perform personal service. And I understand your case on there's wiggle room within that concept. But that then is a restriction on the right of those people who fall within Article 11 but do not meet that single element that's focused on in our domestic legislation, that then is an interference with their Article 11 rights.
Yes. In essence, my lady, that is what we're saying.
Yes, thank you.
So,
Thank you, Lord Henley. That might be a convenient moment.
of course.
To resume 2 o'clock. Thank you very much.